on the publication, the translation and publication of this work, Mr. Tanka, all the distinguished professors on and off the dais. Two of the professors are my professors from the National Law School, Professor Vivek and Professor Elizabeth. And so Vivek asked me to speak on the need for research and writing in the legal scholarship in India in the 21st century. So here I am in a law and economics conference speaking on my experience, which comes purely from a legal education. But yes, I've had a little bit of touch with law and economics. 5 years ago, Professor Nagar had this conference. I think it was the first conference of this society, and all the papers were published of that. And so that is my experience with law and economics. And as a publisher, having access to publishable manuscripts, whether short or long pieces, is the very bread and butter on which such an endeavor survives. And today, a publishable quality manuscript or a short piece is one of the hardest things to come by. I would be doing a disservice to those who have done quality research and legal writing in the past 2 decades. That's my experience. If I said that nothing has been produced or published. But the lament is that it is too far and too few between. It's estimated there are approximately 150,000 students enrolled in law programs in a year, and an estimated 1 million lawyers. And if the BCI figures are to be relied on, then there are about 1,500 law schools, colleges, each of them with many law teachers and professors. And add to this a large number of retired judges. So that is the writing pool that we are talking of. Yet, if one was to count the total number of meaningful short pieces, monographs, textbooks, and commentaries published in 1 year by all the law publishers combined, it's a very, very short list. So where lies the problem? The introduction of the compulsory project writing as part of the teaching curriculum and as method of assessment of the students was probably the first attempt to expose the law student to be given a topic on which she was to do research and then present the research in a cogent written manner, either supporting or critiquing the topic of study. Did such project writing achieve what it sought to? Very few teachers are trained to teach students on how to write the projects. The very early batches who were introduced to this system somehow managed to plod through. As more batches wrote projects, typically on the same topics, rather than an exercise in honing certain skills in the students, it became an exercise in mastering the cut and paste technique. With the internet and easy access to repositories of projects online, this is now only an exercise in mastering how to beat Turnitin and its many avatars. Typically, writing 6 projects a year, that too with analysis and original thought, seems quite daunting. Imagine the plight of the subject teacher who must read through, give meaningful feedback, and evaluate hundreds of projects. And amazingly, every new national law university, and there are 25 or so at last count, replicated this without, I would say, much thought. Mooting, or how to participate in a moot court, is a taught subject in many law schools. But how to write a paper or an article is left to the student to self-learn. Being a mooter or winning a moot brings rock star status to the student in the institution. But getting a paper published in a journal brings little or no recognition. Very little incentive remains to literally burn the midnight oil to produce a meaningful and well-researched piece of legal writing, because a smartly produced piece will do. To a law student, the aim of getting into a law school is now to just get a job, not to learn. When law firms offer PPOs in the beginning of the 4th year, they simply leave no incentive for the student to want to learn anything for the next 2 years. Imagine if getting a paper published in an accredited journal would get a student the equivalent of 1 credit. Further imagine that after giving the PPO, a law firm insisted that in the remaining period of study, the student wrote 3 or 4 papers of publishable quality. In my 20 years of being a publisher, I am yet to come across a PhD thesis, unfortunately, which can be published or is publishable, in the sense that it addresses a real-world legal issue or problem which needs to be researched and written about. Most academic institutions are so isolated from the profession the law firm practice, and the industry. I'll give you examples of just randomly 3 theses which were submitted for publication. One was on the valuation of non-conventional intellectual property. Another one on the standard essential patents and abuse of dominance in the telecommunications industry, analysis of US, EU, UK, India, China, and Japan. A third was on the conflict of jurisdictions under cyber law. On the face of it, these titles all sound meaningful. But when the manuscripts were evaluated by a law firm and industry veteran, he found no value in the works or that they were too pedantic. There are so many new and emerging areas of law for which no analysis is available. And I'll just take, again, 2 examples. There are so many sections of the 2013 Companies Act which has no analysis and would leave even a seasoned practitioner flummoxed. And I got this from a friend of mine who is now a partner of a law firm in Bangalore. Or let's take the PMC bank scam and the legal intricacies to protect deposit interest. Industry is willing to pay lakhs of rupees for one opinion from a retired judge or a senior lawyer. Imagine if some of this money funded the research and publication of LLM and PhD theses. Academia and industry in tandem producing useful and meaningful legal writing. Our law teachers and professors are by and large underpaid and overworked. They are so burdened by the teaching load followed by the assessments, it leaves them little or no time or energy to think, reflect, research, and write. Again, the system is simply skewed for law teachers to keep aiming for promotions so that they at least reach a reasonable standard of living. There is little new learning by the teacher and passed on to the student because there is so little research and writing by the teacher. Unlike, say, the US or the UK, there is little or no critique of judgments by Indian academics, no analysis of the economic impacts of these judgments, and conversely, rarely do judges rely on any available academic writing when writing their judgments. Some may just copy from it and not even acknowledge the author of that piece. Most of the new academic writing on Indian law and its critique is coming from those of Indian origin who are now professors in foreign universities, adequately paid and funded to research, write, and critique. Though some universities have started funding the publication of research and writing, unfortunately the funding is still grossly inadequate and the quality is still subpar. Conversations with senior lawyers, law firm partners, and retired judges on them writing on public law or private law, analyzing complex legal issues jurisprudentially or practically, and producing either a short piece or a monograph or a full book is met with the same refrain. Most say it's directly, some not so directly, that it is not economically viable to invest so much time for little monetary return. India has no continuing legal education for lawyers, whether they are practicing before courts, in law firms, or in-house counsel, and any and all learning is on the job, paid unfortunately by the client. Imagine compulsory continued legal education and a published piece by the lawyer, short or long, counted for credit. India wants to be a $5 trillion economy by 2024. And this economic growth has to be supported by a proper regulatory mechanism, a high level of compliance, and a quick and transparent dispute resolution system. All developed economies have large quantities of quality research published writings to assist in the regulation, compliance, and dispute resolution. India can be no exception. Interestingly, we are in a law and economics seminar. Based on mere economic return, based on royalties from publishers, there is little or no incentive for meaningful legal research and writing. The law student wants a job, the law teacher a profession, and the professional a higher monetary return for her time. I think incentives have to change from merely being transactional to wanting to understand, to wanting to learn, to wanting to create, and eventually to give back the knowledge that has been acquired over many years. And the best way, I think, is to do it in written form, published. It also brings posterity. Thank you.